A baby is born inside a hospital in the United States of America. The mother arrived on a temporary visa. The father is undocumented. That baby draws its first breath on American soil. And for 158 years, the answer to what that baby is has been the same. An American citizen. Full stop. No asterisks, no exceptions. No bureaucrat with a checklist deciding whether that child qualifies for the country they were born in. The President of the United States just tried to change that with a single executive order. And the Supreme Court of the United States is about to tell him whether he can. This is not a case about immigration policy. This is not a case about border security or undocumented workers or any of the other debates you have heard 1,000 times on 1,000 cable news programs. This is a case about the Constitution of the United States, and whether one man with a pen and an executive order can rewrite 158 years of settled constitutional law in a single afternoon. The case is called Trump versus Barbara. Barbara is not her real name. She is a Honduran asylum seeker who was pregnant when this case was filed. She did not choose to be at the center of one of the most consequential constitutional fights in a generation. She just needed to know whether the child she was carrying would be recognized as an American when it was born on American soil. Donald Trump attended the oral arguments himself, the first sitting president in American history to do so. He sat in that courtroom while his Solicitor General argued that the 14th Amendment, ratified in 1868, does not mean what every court in this country has understood it to mean for over a century and a half. And by the time the questions from the bench were done, a majority of the justices, conservative and liberal alike, signaled that the administration's argument had a fundamental problem. The ruling is coming any day now. And when it lands, it is going to shake every assumption about presidential power, constitutional interpretation, and the limits of what one executive order can do to the foundational document that governs 335 million Americans. If this is the kind of coverage you have been looking for, the kind that goes beneath the headline, beneath the talking point, beneath the spin, hit subscribe right now. This story is happening in real time, and the next development will not wait for you to find it. Subscribe, and let's get into what is actually at stake. Here is the thing about the 14th Amendment that Washington has spent years hoping you would not look too closely at. Because the moment you do, the administration's entire legal argument collapses in plain sight. The text of the Citizenship Clause is not ambiguous. It does not require a law degree to read. It says this: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That amendment was ratified in 1868. It was written specifically to overturn one of the most infamous decisions in Supreme Court history, Dred Scott versus Sanford, in which the court had ruled that Black Americans, whether enslaved or free, could never be citizens of the United States. The 14th Amendment was the constitutional answer to that atrocity. It said, anyone born here is American. Not anyone born here whose parents we approve of. Not anyone born here whose family has the right documentation. Anyone. In 1898, the Supreme Court took up the case of Wong Kim Ark, a man born in San Francisco to Chinese parents who were legally present in the United States but could not become citizens under the discriminatory laws of the era. The court ruled 6-2 that Wong Kim Ark was an American citizen, not because of his parents, because of where he was born. The Citizenship Clause, the court held, meant exactly what it said. That ruling has been the law of the land for 128 years. On January 20th, 2025, hours after being sworn in for his second term, President Trump signed Executive Order 14,160. It was titled, Protecting the Meaning and Value of American Citizenship. And what it did was instruct the Department of State, the Department of Homeland Security, the Attorney General, and the Social Security Administration to stop recognizing birthright citizenship for children born in the United States to parents who were undocumented or here on temporary visas. Read that again slowly. A presidential executive order instructing federal agencies to stop following a constitutional amendment that has been the settled law of this country since 1868. Every single federal court that reviewed that executive order blocked it. Not one judge, district court, or circuit court, appointed by Republicans or Democrats, found a legal basis to let it stand. The order has never gone into effect, not for a single day. The constitutional wall it ran into was too high and too solid. But the administration appealed, and the case arrived at the Supreme Court of the United States in Trump versus Barbara, where oral arguments were held on April 1, 2026. And the ruling that will determine whether 158 years of American constitutional history survives this administration is coming now. Before we go deeper, I need you to understand the scale of what is actually at stake here, because the mainstream coverage is consistently underplaying it. Every year, roughly 150,000 to 250,000 children are born in the United States to parents who are undocumented or here on temporary visas. Under the constitutional understanding that has governed this country since 1868, every one of those children is an American citizen from the moment they take their first breath. If Trump's executive order had gone into effect and the Supreme Court upheld it, those children would have been born stateless, not American. Not citizens of their parents' countries either in most cases. Stateless. A word that means you do not legally belong anywhere. A word that should not exist in the vocabulary of a country that built itself on the promise that where you come from does not define what you can become. The Migration Policy Institute ran the numbers. If birthright citizenship had been eliminated from the moment Trump signed that order, by the year 2045, the United States would have an additional 2.7 million unauthorized immigrants, the exact population the administration claims it is trying to reduce. Because those children, born here, raised here, educated here, would have grown up without legal status in the only country they had ever known. This is not just a legal case. This is a case about what kind of country America is. Whether citizenship is a birthright or a bureaucratic determination. Whether the Constitution means what it says or what the current administration wishes it said. And 6 justices signaled during oral arguments that they knew exactly what was at stake. Let me tell you what actually happened in that courtroom on April 1, 2026. Because what happened there tells you everything about where this ruling is going. Solicitor General D. John Sauer stood before the 9 justices and made the administration's argument. He said the 14th Amendment's phrase, "subject to the jurisdiction thereof," was never intended to apply to children of undocumented immigrants or temporary visa holders. He said the amendment was written specifically and narrowly to address the citizenship of formerly enslaved Black Americans, and that it should be read through that narrow lens today. The justices did not let that argument breathe for long. Chief Justice John Roberts pushed back hard. He challenged the administration's attempt to take a narrow historical exception, the exemption for children of foreign diplomats, and expand it into a broad principle excluding entire categories of immigrants. He found the logic, in his words, difficult to justify against the actual text of the amendment. Justice Neil Gorsuch, one of the conservative justices the administration might have expected sympathy from, was equally skeptical. He pointed out that in 1868, when the 14th Amendment was ratified, the United States had no meaningful federal immigration laws. Anyone could arrive in this country and establish residence. The concept of illegal immigration in the modern sense did not yet exist. Gorsuch asked how a clause written in that context could be interpreted to exclude people based on modern immigration categories that did not exist when the clause was drafted. Justice Elena Kagan went further. She told the Solicitor General that the 1898 Wong Kim Ark decision had a very clear rationale, that the historical tradition of citizenship by birth had carried into the United States, and that the 14th Amendment accepted that tradition without limitation. She challenged Sauer to explain how 128 years of settled precedent could simply be set aside by an executive order. The administration's argument, presented in that courtroom with the president himself sitting in the audience, did not land. It did not find purchase even among the conservatives it most needed to persuade. And legal observers who watched those arguments across the ideological spectrum came out of that courtroom with the same read. The court is likely to reject the executive order. The question is not whether. The question is how broadly, and what the ruling says about presidential power going forward. We are past the midpoint now, and this ruling has implications that go far beyond the children whose citizenship it directly decides. If you are watching this and thinking clearly about power and constitutional limits in America right now, this is the part you need to hear most. Subscribe, share this with someone who is paying attention to what this administration is doing to the constitutional order, and let's keep going. Here is what the ruling, however it comes down, will actually mean for the country. And I want to be direct about all of it because there are consequences that go in every direction, and honest coverage requires acknowledging all of them. If the court rejects Trump's executive order, as the majority of legal observers expect, 158 years of settled law is reaffirmed. Children born on American soil remain American citizens. The executive branch is told clearly and formally that a presidential order cannot rewrite a constitutional amendment. And the administration's broader theory of executive power, that the president can reinterpret constitutional provisions unilaterally, takes a significant hit. That is a consequential outcome. Not just for the children directly affected, for every future administration that might reach for the same tool. The court would be drawing a line between legitimate executive power and constitutional revision, and it would be drawing it in ink that lasts. But here is what even a favorable ruling does not resolve, and any honest analysis has to say this plainly. The underlying political debate about immigration, about who should be eligible for citizenship and how immigration law should be structured, that debate does not end with this ruling. It cannot. It should not. Because that is a question for Congress, for elected representatives, for the democratic process. If a future administration or Congress genuinely wants to change the framework of birthright citizenship, the Constitution itself provides a mechanism. It is called a constitutional amendment. It requires 2/3 of Congress and ratification by 3/4 of the states. It requires democratic consensus on the scale that a change this fundamental deserves. What it does not permit is one president and one pen bypassing that process entirely. And that is the deeper principle this case is really about. Not just birthright citizenship, not just immigration. The question of whether the executive branch of the United States government can rewrite the foundational law of the country by executive order. And what happens to the constitutional order if the answer is yes? The immigration arena is where this plays out first, but it is not where it ends. If a president can reinterpret the citizenship clause of the 14th Amendment by executive order, what constitutional provision is safe from the same treatment? The First Amendment? The Fourth? The Equal Protection Clause? The constitutional order is either a binding document or it is a suggestion. And the Supreme Court of the United States is about to tell this country which one it is. The political fallout from this case has been building since January 20th, 2025. and it is going to intensify the moment the ruling drops. Inside the White House and the Department of Justice, officials have been managing the expectations gap between what the president publicly predicted and what the legal reality appears to be. The administration filed its briefs confidently. It sent its best advocate to argue before the court. It sent the president himself to watch. And what came back from the bench during oral arguments was a bipartisan wall of skepticism that legal teams on both sides have been reading the same way. State attorneys general, particularly from blue states, have been lined up and ready for the moment this ruling comes down. Legal briefs are drafted. Press statements are staged. The infrastructure for the post-ruling response has been built for months. Because everyone who has been paying close attention to this case has understood that when the decision lands, it lands fast and it lands hard. On the other side, the states that filed amicus briefs supporting the administration's position are already calculating their next move. If the court rules against the executive order, the political question shifts immediately to Congress, to whether a legislative path exists for the restrictions the administration sought through executive order. That legislative path faces its own constitutional constraints and its own democratic reality, but the conversation will happen regardless of how the court rules. And here is the dimension that almost no mainstream coverage is addressing directly. This case exists because the administration believed, or chose to act as if it believed, that 158 years of constitutional interpretation could be reversed by executive action. Whether that belief was sincere or strategic, the court's response will set the terms for every administration that comes after this one. It will define what presidential power over constitutional interpretation actually means in the 21st century. And that definition will outlast this presidency, this term, this political moment, by decades. There is something that needs to be said plainly at the end of this, something beneath the legal doctrine and the constitutional theory that is the real core of what this case is about. The 14th Amendment was written in blood. It was ratified 3 years after a civil war that killed 620,000 Americans. It was the constitutional settlement of the most devastating conflict in American history. And the principle it established, that birth on American soil confers American citizenship, was not a procedural convenience. It was a moral declaration, a statement about what this country would be after it had nearly torn itself apart. That declaration has survived 158 years. It has survived presidents, wars, recessions, social upheavals, immigration debates, and every political storm the country has weathered in a century and a half. It survived because it was written into the highest law of the land by people who understood that some principles need to be beyond the reach of whoever happens to hold power at any given moment. An executive order signed on Inauguration Day tried to reach past that protection. Federal courts stopped it at every turn. And now, 9 justices of the Supreme Court will have the final word. The ruling is coming. It is coming now, in the final days of the court's term. And when it arrives, it will tell this country something fundamental about whether the constitutional architecture that has held American democracy together for 158 years can withstand the pressures of this particular political moment. The question for every one of us watching is the same question it has always been. Are we paying attention? Are we willing to understand the actual stakes rather than the simplified version? Are we willing to defend principles not because they are convenient, but because they are right? Because the Constitution does not enforce itself. Courts interpret it. But citizens have to care about it. And you cannot care about something you do not understand. Subscribe right now, not for the algorithm, for yourself. Because when this ruling drops, you need to understand every word of it. And you need a place that will not let it get buried under whatever the 24-hour news cycle decides is more engaging that day. Share this with someone who has been watching this case and wondering what it actually means. And drop a comment. Do you think the court will reject the executive order outright? Or is there a narrower ruling that leaves the door open? That conversation is the one worth having. Let's have it.